appeal in the matter of HFFX LLP and others, and the Commissioners for His Majesty's Revenue and Customs.
So, good morning. I think people are still getting a little bit organised behind, and also I'm struggling with my lamp, but it does help if you switch it on.
Mr. Chaco's wig is just being brought into court.
Lovely. Very, very good.
It's on. It's on him.
Yeah. He's there, almost. Good morning, everybody. And we've had a good opportunity to read into this case. As your skeletons reveal, part of it is no longer live, and that's the section 850 point.
Yes.
And so we assume, and especially as also we've, as you say, had the opportunity to read, that in fact what is left can be done in a day. Is that right?
I hope so.
Good, lovely. And then secondly on that point, we would be grateful if you could organise your submissions so that we deal first with the miscellaneous income point, and that we hear all of that before the sales of occupation income point, and that we will consider where we are when we've heard the miscellaneous income point. If that's convenient for you, we'd be grateful.
Sure.
Thank you very much.
So I appear with
I'm
David
so
Yates.
sorry not to have let you even say that.
With David Yates, KC for the appellants, and Tom Chaco and James Kirby appear for the respondents, HMRC. So I don't think I need to give you much of an introduction, but I do need to explain that the appellants are the individual members of HFFX LLP, and they, under the leadership of one of them, Alex Gerko, who was the managing member of that LLP, were seconded to work in a business of foreign exchange trading, and as such they were responsible for designing and operating the automated high-frequency Forex trading systems used in that business. Now, the FTT called that business the GSA business because it was carried on by another LLP called GSA Capital Partners LLP. That LLP was managed by a company called GSA Capital Services Limited, and that company was also the corporate member of HFFX, in which capacity it had various overriding controls over the operation of HFFX. Now, 50% of the profits of the GSA Capital Partners LLP generated from that automated Forex trading were allocated to HFFX as a member of that LLP. GSA CS, the corporate member of HFFX, insisted that HFFX should operate a remuneration deferral mechanism called the Capital Allocation Plan, or CAP, in order to incentivize the individual members and to comply, in particular, with an anticipated requirement of the Financial Conduct Authority. Now, in accordance with the CAP, what happened was that 50% of the profits, which would otherwise have been allocated to the individual appellants, were instead allocated to another corporate member of HFFX called GSA Member Limited, GSAM, which was called the retention member. The shares in GSAM were held on a purpose trust, the purposes of which were to promote the businesses both of GSA Capital Partners and HFFX. So profits were allocated to GSAM, it paid corporation tax on those profits, it invested the balance, and then subsequently, on the first, second and third anniversaries of that allocation, GSAM, at the recommendation of Alex Gerko, the managing member, sold 1/3 of the investments, contributed the proceeds back into HFFX as what was called special capital, and then shortly after that, again in accordance with Alex Gerko's recommendation, decided to reallocate that special capital to the individual appellants, and then finally GSAM actually reallocated it to them. Now, HMRC assessed the appellants on 3 alternative grounds. Lady, you've mentioned the first ground, which is no longer in dispute, which is the Section 850 ground. Ground 2 was that the special capital was the income, miscellaneous income of the individual appellant, in accordance with Section 687. And then the third ground was the sales of occupation income ground. And obviously, the individual appellants, they lost their appeals before the FTT and the Upper Tribunal on those second and third grounds, and that's why they're here before this court. Now, your ladyships will be well aware of the Blue Crest decision of this court. In Blue Crest, this court held that Section 687... Sorry, I should mention that in Blue Crest, the court didn't consider the sales of occupation income point because that wasn't necessary to do so, because the court reached its decision on Section 687. It held in relation to 687 that that section applied to the special capital allocated to the individuals in that case. But I submit, for reasons which obviously I'll go on to explain, that this case is distinguishable from Blue Crest. Now, Mr. Yates, if we get that far, will make our submissions on the sales of occupation income issue, and I will begin, therefore, with the Section 687 issue. Now, in Blue Crest, and that's in the authorities bundle at tab 28, at paragraph 101 on page 1176 of the authorities bundle.
Do you want us to turn it up?
Yes, please. Just 2 paragraphs I wanted to refer to, please.
Please, could you give me the page reference again?
Yep, page 1176.
1176. Thank you.
Sorry, we're looking at tab 28.
26.
26.
Is that me? Sorry.
No.
38.
I'm sorry, it's 38. I beg your pardon. I don't know why I said 26. So it's paragraph 101 on page 1176.
I'm so sorry to be so slow. No, I am still sorry.
76.
Yes.
At the top of that page, paragraph 101.
Yes.
To be taxable under case 6, now section 687, the receipt must be of the nature of income, and it must be of the same type as or analogous with some other head of charge to income tax. So that was the first proposition. It's always been accepted in this case that those conditions are satisfied here. This is on the basis that GSAM allocated the special capital to the individual appellants, effectively in return for work they had done, the work that Mr. Yates will, if we get that far, consider in more detail. And so the receipt of the special capital by them was comparable with a discretionary bonus paid to an employee. So it's accepted that those conditions mentioned by Sir Lancelot Henderson at paragraph 101 were satisfied here.
And that was the case even before the FTT,
Yes,
was it?
it was.
So this wasn't, so unlike Blue Crest where it was argued that it was a capital
Yeah, we never argued it was capital.
transaction. So the argument always focused on
Source.
source,
Yes.
essentially.
Yes, that was the sole argument in relation to miscellaneous income. So that takes me then to paragraph 102, where Sir Lancelot Henderson says that a further requirement implicit in the wording of section 687 is that the income must arise from an identifiable source in the relevant year. And he says that follows from the opening words of the subsection, which impose the charge to tax on income from any source that's not charged to income tax. And then he says it was left open, but, and so on. Then he refers to the general rule, an assessment for a year requires a taxable subject matter in that year. So that was left open before, but my submission, Sir Lancelot Henderson said that is indeed a requirement of Section 687.
You accept that, do you?
Well, I rely on it.
Okay.
Now, in this case, HMRC contend, and the tribunals below both held, that there was an identifiable source, indeed two alternative identifiable sources. The first was the activities of the individual appellants. My submission about that is that activities without more cannot constitute a source of miscellaneous income, that what is required in addition is that the activities must give rise to a right to the income. Whereas in this case, I submit, the individual appellants at no stage had a right to receive the special capital. Obviously they received it, but until they received it, they had no right to it. That's my submission. And therefore, I say that the tribunals below both erred in law in holding that the individual's activities were a source of miscellaneous income. And I'll come on in a moment and refer to a couple of authorities which I submit are authority for the proposition that there must be a right to the income. Now, in Blue Crest, HMRC didn't argue that the activities in that case were a source of income. And so that issue wasn't considered by this, either by the tribunals below or by this court. Obviously, the activities of the individuals were very important in that case in relation to the point that Sir Lancelot Henderson mentioned at paragraph 101, the nature of the receipt. It was of an income nature because of the work that the individuals had done. So their activities were very relevant to that question. But HMRC didn't argue that the activities were themselves a source. So that's the first point, and I'll make my submissions on that as to whether activities without more can be a source of income. Then the second alleged
sorry,
source,
on that
yes,
point,
yes.
you'll come back to it.
Yeah.
When you say that you need a right to receive, do you maintain that the Sprite bean case is wrongly decided?
Yes. In that case, the tribunal rejected...
So I'm sure you'll come back to it, so I don't want to take you out of your course.
Okay. And then the second source, according to HMRC and the tribunals below, was the decision by the retention member, GSAM, to reallocate the special capital. Again, however, I submit that a decision without more cannot constitute a source of miscellaneous income. Again, what is required, in addition, is that the decision must confer a right to the income. And therefore, I submit again that the tribunals below erred in law in holding that GSAM's decision was a source of miscellaneous income. Now, in Blue Crest, by contrast with the activities as a source point, HMRC did contend that the decision by the corporate partner in that case to reallocate the special capital was a source of miscellaneous income. And in this court, in the judgment of Sir Lancelot Henderson, held that a source could indeed be found in the exercise by the corporate partner of its discretion to award special capital. Especially, he said, as it was common ground that the discretion wasn't unfettered and had to be exercised in accordance with the principles in the Braganza case. However, obviously I can't say that's wrong, and I'm not going to suggest that it's wrong. I submit that in Blue Crest, the exercise by the corporate partner of its discretion did confer on the individual partners a right to receive the special capital, and it's implicit, at least, in Sir Lancelot Henderson's judgment that it had to do so in order to constitute a source of miscellaneous income. And by contrast, as I've already submitted, in this case, there was at no stage any such right.
So is that a contractual point? So you say the contracts are different? Blue Crest contract, the Blue Crest LLP deed was different.
I haven't seen the terms of the LLP deed in Blue Crest, but
you make some points
there
about
are
your
some,
contract.
There are some statements by the Upper Tribunal about this question of contractual rights, and I will make my submissions about the terms of the LLP deed in this case, why there could not be any contractual right arising as a result of the taking of the decision. Obviously, I will as briefly as I can, make those points by reference to some provisions of the LLP deed in this case.
I mean, is also implicit in that you need to say that Sprite Beam is wrongly decided on that second alternative as well? Or is it a different point?
Insofar as my argument in relation to both alleged sources is you need to have a right, yes. Sprite Beam says you don't need to have a right. What Sprite Beam said was it's enough that you have an obligation to make a payment. My submission is that's a misunderstanding of the authorities, and obviously I'll go on to look at Sprite Beam. But yes, effectively, I'm saying that Sprite Beam is wrong in saying you don't need to have a right. Now, if I'm wrong about the need to have a right in relation to this decision point, in other words, can a decision be a source of miscellaneous income? If instead it's sufficient, if this is the correct interpretation of Sir Lancelot Henderson's judgment, it's sufficient that there is a discretion which is a fettered discretion. If that is a sufficient condition, well, my submission then is that the discretion exercisable by GSAM was absolute and was not fettered. It was common ground, Sir Lancelot Henderson said, in Blue Crest, that the discretion of the corporate partner in that case was a fettered discretion, fettered in the Braganza sense, that it had to be exercised in good faith and so on. Again, I would like to take you to a couple of provisions of the LLP deed to make the point that in this case the discretion was absolute, expressed to be absolute, and it may be contrasted with other provisions of the deed which refer to discretion having to be exercised in good faith. And I will contrast those provisions to make the point that the drafter of the LLP deed could not have done more to make it clear that the discretion in this case was an absolute, unfettered discretion. So in summary, and as quickly as possible, I would like to make 4 submissions. The first is that activities cannot, without more, constitute a source of miscellaneous income. What's needed in addition is a right to receive it. That's the first one. The second one is a decision cannot, without more, constitute a source of miscellaneous income. Again, what's required in addition is a right to receive it. The third one, following on from the second, is that in the present case, the individual appellants at no stage had a right to receive the special capital. And the fourth one, if my second submission is wrong, and you don't need to have a right, but a source can be found in the exercise of a fettered discretion, my final submission is that GSAM's discretion was an unfettered, an absolute discretion. So if I can then start referring to some authorities, and I'd like first of all, if I may, to refer you to a case which discusses the source doctrine, a case called Bray and Best in the House of Lords, which is at tab 25 of the authorities bundle, page 303. The case starts at page 297, but I don't think I need to explain what the facts were. If I can take you to page 303, opposite G, this is in the speech of Lord Oliver, and there's a sentence directly opposite G beginning, "It is a well-established principle, deriving from the nature of income tax."
Sorry, it lost the page number. Can you give me that again?
303.
Thank you very much.
Opposite G near the bottom of the page.
Got it.
It's a well-established principle deriving from the nature of income tax as an annual tax that a receipt or entitlement arising in the year of assessment is not chargeable to tax unless there exists during that year a source from which it arises. And then he says that principle is conveniently expressed in Whiteman and Wheatcroft as follows: most types of income are classified by reference to the source from which they come. From this it was held to follow that if a taxpayer ceased to possess a particular source of income, he could not be taxed on delayed receipts from that source, unless these were referable to and could be assessed in respect of a period during which he possessed the source. That's it. Now, Lord Oliver begins by talking about the source existing during the year, and then there's a reference in Whiteman and Wheatcroft to the taxpayer possessing a source of income. And this is relevant to the Sprite bean case, but in particular, and I'll explain why when I get to Sprite bean, but these concepts of a source existing and a taxpayer possessing the source are one and the same thing in my submission. That the source is something relating to the taxpayer, which one can sensibly say the taxpayer possesses. And if I can give an example, if I carry on a trade in a particular year, then I have a source of income that's the trade. If I sell the trade to somebody else, transfer the trade, you can't say that the source exists in somebody else's hands. The source has ceased to exist, and I have ceased to possess it. They're one and the same thing. Now, my submission is that those concepts of a source existing and a source being possessed by the taxpayer do cast some light on what is meant by a source of income.
Can I just pause there? You've taken us to this case and this reference to Whiteman and Wheatcroft. Is this concept of possession discussed elsewhere?
Well, it's referred to in the legislation, and I'm going to take you to the legislation in a moment. It's recognised throughout the legislation. So it's not just a made-up thing of Whiteman and Wheatcroft.
Okay, but in terms of judicial consideration, is this the primary authority? Which you
well, no, there's another one. The next tab, on page 309, is a case called Puma Haven. Mr. Justice Park, who I hope one would agree is an expert in this area. So that begins at page 309, and the passage I wanted to refer to is at page 330. This is paragraph 20 of his judgment in that case, on page 330. He says, so at 19 he refers to the source doctrine, and then at 20 he says, further, and critically for the argument in this case, the taxpayer must possess the sources in the year of assessment or accounting period in which the income arises. If the taxpayer receives income from a source which the taxpayer no longer possesses in the year, and so on, the effect of the source doctrine is that in principle, subject to any detailed statutory provision to the contrary, the income is not taxable. So, judicially, it's a recognised concept of a taxpayer possessing a source. Now, I said that the tax legislation recognises it as well. If we go to tab 1 of the authorities bundle, pages 4 onwards contain a number of examples. And if I can just give you 3 examples of this concept being used in the legislation. The legislation here is the Taxes Act 1988. And I did that because that's before the division into different acts. But because HMRC say I shouldn't be harking back in this way to the Taxes Act 1988, I am going to take you also to 2 examples in the current legislation. But if I can start anyway, as briefly as I can, with the Taxes Act 1988.
And that should be at Divider 1.
Yes, it's Divider 1 and it begins on page 4 of the authorities bundle.
My dividers are empty until I get to page 26.
Yeah.
But I'm very happy to take a note and...
I apologise.
No doubt.
Have you got...
Oh, thank you. I'm very grateful. Thank you.
I think it's
Thank you very much indeed.
So if I could give you 3 brief examples. First of all, on page 10. This is section 66 of the Taxes Act 1988. At subsection 3, it says, if at any time a person acquires a new source of income. And at subsection 5, likewise, as if that security or possession were a new source of income acquired by that person. And then on page 12, section 67, subsection 1 says that if in any year of assessment a person and so on ceases to possess any particular source of any such income.
Where do you find that?
In subsection 1?
Line.
Yeah, the second line,
Thank you.
ceases to possess any particular source of any income. Likewise at C1, which he ceases to possess. And then likewise in subsection 5, a person possessing a source of income and having possessed it for 6 consecutive years of assessment. And then over the page on page 13, there's also in 5A, as if he'd ceased to possess it, and then B, as if he'd acquired the source as a new source. And then finally, subsection 8, which he ceased to possess before his death. And then finally, on page 24, section 751.
Still in the Tax Act 88. Yeah?
I'm still in the Tax Act 88.
And it was page.
Page 24.
Thank you.
This is 751. Subsection 1C talks about the company having any source of income. And in subsection 2C, the company ceases to have any source of income whatsoever. Now, I would submit those concepts of acquiring and possessing and having, they're all the same. Obviously, they're using different language, but the idea is the same. And then I said I would, and unfortunately, these are not in the bundle, but if I may hand up. Now, hopefully you've got 3 tab or bits of paper there. The first is section 844 of Itoya 2005.
Yes.
Yeah. And in subsections 1 and 4, I wanted to draw your attention to the references there. In subsection 1b little 2, has ceased to possess that source. And then subsection 4, as if the person continued to possess that source. And then the other example I wanted to give you, the second bit of paper there, hopefully, is section 1261 of the CTA 2009. And it's in subsection 2b. Acquires a source of income. So those concepts of possessing and acquiring a source of income are still current. So they're judicially recognised concepts. They're legislatively recognised concepts, and in my submission, as I say, they cast some light on what's meant by a source of income, in the sense that it's something which the taxpayer has or possesses or acquires or ceases to possess, and so on. And so my submission is, obviously, this is by no means a determinative point, and I'm going to take you to some cases which are more directly in point, but my submission is that a decision by another person to pay money to someone cannot sensibly be regarded as a source of income, as something which the taxpayer, a decision which the taxpayer possesses or has or acquires. By contrast, I would submit it is possible to regard a decision which confers a right on the taxpayer to receive the payment can be regarded as something which the taxpayer has or possesses or requires. So then I turn specifically to my first submission, which is that activities cannot, without more, be a source of income. And there are two cases I wanted to refer to. They're both authorities on Schedule D Case 6, the predecessor to 687. But in Blue Crest, Sir Lancelot Henderson said those cases are just as relevant to Section 687. He said that at paragraph 98 of his judgment. So the first one is Brocklesby and Merritts, which is in tab 16 of the authorities bundle at page 177. And if I may ask you to read the head note on page 177, it's quite short. So you see at the very bottom there that the statement in the head note, the payment was made in fulfilment of an enforceable contract for services and was correctly assessed under Case 6 of Schedule D. And if I could ask you to go to page 184 in the judgment of Mr. Justice Finlay, and please may I ask you to read halfway down, there's a paragraph beginning, the appellant's contention was. Could I ask you, please?
Is this in the High Court or the Court of Appeal?
This is in the High Court. Because the Court of Appeals say, I wish we'd just said we agreed with Mr. Justice Finlay. On page 184, there's a paragraph beginning, the appellant's contention was. If I could ask you to read down to the end of his judgment at the top of page 185.
Thank you.
And then, so you see the various references of Mr. Justice Finlay to there being an enforceable contract for services. Then in the judgment of Lord Hanworth on page 185, he says, this case is simple, I should be content to leave it where Mr. Justice Finlay had left it in a very careful judgment. And then he goes on and says something himself on pages 185 to 186. And in the middle of the paragraph at the top of 186, he says, that seems to me evidence that a mutual agreement had been arranged, and so on. So he doesn't put it in exactly the same terms. Then he says, thereupon I think the learned judge is quite right in holding that the position was that the appellant could have enforced his rights. And then a case which maybe emphasises this requirement a bit more clearly is a case called Manduka and HMRC, which is tab 29, page 551. Could I ask you please to read the head note on page 551 and the top of page 552? So you see that in the head note, Mrs. Justice Rose is recorded as saying that once it was established the payment was an income receipt and that it was paid pursuant to a binding contract in return for some kind of service, there was no need to go further and so on. And if I can take you to her judgment, paragraph 29 on page 559. Paragraph 29 on page 558. So there she refers at 29 at the bottom of page 558 to Brocklesby and Merrick's. I don't need to go through that again. She quotes Mr. Justice Finlay in the middle of page 559 about having an enforceable right to get it. And then at paragraph 31, she refers to another case, Bradbury and Arnold. And at the bottom of page 559, she records Mr. Justice Upjohn as saying there's no doubt that a contract for services may, and clearly does, form a matter for assessment under case 6 of Schedule G. And then if I can take you to paragraph 34 on page 560, she records Mr. Bremner for HMRC's case. The principles derived from the case law showed there was no need to consider what the taxpayer actually did in performance of the agreement. It was enough that the payment was made under a binding agreement rather than as a gratuity, and the agreement bound the taxpayer to provide some kind of services. And then in 35, she says, in my judgment, the bonus was remuneration for services provided. Those services fall firmly within case 6. I accept Mr. Brendan's submission that Brocklesby and Merrick's and Bradbury show that once it's established the payment was an income receipt rather than a capital receipt, and it was paid pursuant to a binding contract in return for some kind of service, there's no need to go further to inquire into the extent of the services in fact provided. Now, HMRC say, well, that's wrong. There is no need for...
well, hang on.
Yes.
It's one thing to say it's wrong. Another might be to say that Mrs. Justice Rose was saying that those elements were sufficient to create an income receipt. She perhaps wasn't setting out to describe a full list of everything that gave rise to miscellaneous income, or D6 income.
That is a possible interpretation. My submission is that she was going further than that and saying that that is a requirement, that it's not enough that you have a service and a gratuitous payment in return for it, that you need to have a contract giving a right to it. But perhaps I can pick that point up when I deal with the decision as a possible source and the authorities in relation to that as well, because some of those cases, in particular a case called Stedderford and Below, are ones which also involve an element of services having been provided.
Yes.
And there again, my submission is that the case shows that you do need to have a right to be able, in that case, the right on the part of the headmaster, Mr. Below, to receive the payment in order for it to be taxable.
But the Below case was receipts, I use that in a general sense only, by the headmaster, or after he had ceased to be headmaster.
True.
And they didn't relate directly to his services.
Well, with respect, they did in the sense that it was recorded, I think in the Court of Appeal, that it was because of those services that...
Well, they didn't pick someone off the street and say, we'd like to pay you some money.
No.
They paid money to an ex-headmaster. But I'm not sure, and you'll take me to it, I'm sure, that there was a direct correlation between the services which had been rendered and the payments which were made. Anyhow, you'll come to it, I'm sure.
I will take you to the bit in the Court of Appeal which discusses that. Well, in any event, HMRC rely on a different case called Alloway and Phillips, which is at tab 24, page 278. Now that was...
Sorry, I had to keep swapping between bundles,
Yes, me too.
which takes a little bit of time and makes me much more eager to use an electronic copy next time. 24, tab 24.
Tab 24. Yeah. This was a case about Mrs. Alloway, who was the wife of one of the great train robbers, and she wrote an article about the robbery or her connection with it through her husband, and she got paid for it, and the question whether the payment was taxable or not. Now, she was non-UK resident, and she performed her work, she did the work, talking to the newspaper, giving her story, in Canada, so outside the UK. Now that's relevant because in order to be able to tax that receipt, HMRC had to show that there was a UK source of the income. It was no good them relying on her activities as the source, because those activities, as I say, were carried out abroad and she was non-resident. So this case isn't about activities being a source. HMRC's reliance on it, in my submission, is misplaced. If we... you see, halfway down the headnote, there's a reference to a charge imposed by Section 108 of the Taxes Act 1970. And if you go to page 279, a third of the way down, paragraph 2 of the case stated sets out Section 108. Annual profits or gains arising or accruing to Mrs. Alloway, although not resident in the UK, from any property whatever in the UK.
Sorry, where are you reading?
Yeah, this is a third of the way down, page 279.
Oh, I see.
So that's what Section 108 of the Taxes Act 1970 said.
So it had to be property in the UK.
Property in the UK. So it wasn't about activities being a source.
well, it's analogous though, because they had to identify something in the UK.
Yes, but the activities were not in the UK. As I say, they'd been carried out in Canada. So they weren't relying on the activities being a source. What I'm saying is HMRC is saying this case is authority for the proposition because they refer to something that Mr. Justice Brightman said, and I'll take you to that in a moment. But it's not about activities being a source. It's about property being a source. And the property that was identified, both by Mr. Justice Brightman and the Court of Appeal, was her contractual rights against the newspaper. Because Lord Denning said that those rights were enforceable in the UK courts, and therefore they were situated in the UK. So that was what the case was about. Now, in any event, what HMRC rely upon is something said by Mr. Justice Brightman at page 286. Now, do you see the marked paragraph there on page 286, near the bottom of the page? Counsel for the appellant argued before me in the first place. The agreement was unenforceable. So, first of all, Mr. Justice Brightman says, in my judgment, the appellant's first submission is unsound. There was ample evidence to justify the finding of ratification. Then he says, I've been referred to no authority to support the proposition that it was void as against public policy.
No, that's not quite what he's saying.
Sorry, middle of the page. I have been referred to no authority to support the proposition that it was void as against public policy.
Well, yes, but at the end of the...
No, I'm going to take you to the end. I'm just taking you through the paragraph.
Apologies.
And then he says, finally, the last sentence, nor have I been referred to any authority for the proposition that money received and retained under a contract, void as against public policy, escapes taxation for that reason. Well, the first point to make there, obviously that's an obiter dictum. But given that this case was about whether there was property, profits arising from property situated in the UK, it's odd, I would submit, to be saying that even if the contract is void, it doesn't escape taxation. But even if he was making a more general proposition that the fact that it's void doesn't matter, clearly what he wasn't doing, in my submission, was considering the general question which I'm asking this court to consider, which is there a requirement under Schedule D Case 6 that there is a right to be paid as opposed to simply activities? That wasn't what he was considering. That wasn't relevant to the case. So I would submit that HMRC's reliance on that sentence, that obiter dictum of Mr. Justice Brightman, is misplaced insofar as it suggested that it somehow supports an argument that you don't have to have a right. And I won't take you to what the Court of Appeals said. They didn't consider the question of the contract being void for public policy because I suppose it had been abandoned. And they simply held there was a source, property in the UK, consisting of the contractual rights of Mrs. Ellaway.
I'm probably being extremely slow, Mr. Prosser, but just trying to stand back and thinking about your argument about activities and needing a right to receive.
Yeah.
Do I take it that that argument is specific to old case 6, miscellaneous income?
Yes.
Because obviously
yes.
an employee who
Of course.
receives a discretionary bonus,
Yes. Or a trading receipt.
or a trader who receives
Yep.
extra bung from
Yep.
a satisfied customer,
Yep.
no one's going to
No.
seriously argue.
Or argue, seriously or otherwise. I'm not suggesting that.
So just help me out as to why, if you like, why is it different when you get to miscellaneous income?
Well, first of all, you have a specific, under the old scheduler system, even now you have a specific head of charge of income from a trade, income from employment and so on. But once
so you say the source is the trade
Yes.
or the employment.
Yes. But once you move away from those specific categories of a trade or employment, and you move into the residual category, my submission is that what the courts have effectively said is that a mere activity, a mere service, is not enough. It's clearly not enough by definition to constitute a trade, let's say. So what more is required is not simply that there is some sort of activity, but that it confers a right to the income. That is the extra feature which enables it to be taxed.
So you say that the contrast to the purely voluntary, which is a terminology that I think is used,
Yeah.
the only contrast to that is within the charge is something paid pursuant to a right.
That's my submission, and that when one looks at the old cases which talk about something being voluntary, what the courts there are doing is using the word voluntary in the same sense as equity doesn't assist a volunteer. That it's a contrast to someone having a right. That becomes clear in my submission when one comes to Stediford and Beeler, which I'll take you to in a moment. That that's what the courts, maybe it's an old-fashioned sense of the word voluntary, but in any event, that's what they mean by a payment being a mere voluntary payment, that you can't sue on it. It's not, doesn't mean any more than that. Can I then take you to the next authority, which is a case called Drummond and Collins, and that's tab 6, page 56. Now, this was a case about income from a foreign source. It was an offshore trust. And the question was whether there could be a charge to tax under Schedule D, Case 5, which was to do with foreign possessions. And one might say, well, what's that got to do with Schedule D, Case 6? But Schedule D, Case 5 was the equivalent of Schedule D, Case 6 for foreign source income. So that one couldn't have a charge under Schedule D, Case 6 if the source was a foreign source. It could only be under Schedule D, Case 5. And so,
what were foreign dividends charged under at the time?
Well, they were either Case 4 or Case 5. So if Case 4 was to do with security.
So Case 5 is wider, always was wider than Case 6 because Schedule F covered UK dividends.
Well,
or maybe not at the time, that's what I'm trying to remember.
No, I think, so Schedule F was a different schedule, but I was looking at cases of Schedule D.
Yes.
And Case 5 was the sweeper up, as it were, of foreign source income.
Okay, and you say D6 didn't cover foreign source?
No, and if I can just, one of the bits of paper I handed up was the explanatory notes to...
That's the rewrite expansion.
Yes,
right.
now that was handed up, or is requested by the court in Blue Crest. And Sir Lancelot Henderson referred to it.
I think I might have requested
Right.
it. Might be my fault.
Right, no, it was very helpful, because if you go to paragraph 2629, could I ask you to read paragraph 2629? That makes the point that D5 is the equivalent of D6 for foreign source income.
Thank you.
So it's the last sentence, I suppose. Case 5 is the last resort charging provision, not Case 6, for foreign source income. So that's why I would submit that Drummond and Collins is relevant here. Although it's about Schedule D, Case 5, it's about the the equivalent of Schedule D Case 6 if you're looking at a foreign source income. So if I could ask you to read the head note, please. So the trustees had a discretion whether or not to pay income to these beneficiaries. And the argument, well, if I can take you to page 63, we'll see exactly what the argument was for the taxpayers. Halfway down the page, the argument is set out: the monies remitted by the trustees are not taxable as having been received in respect of foreign possessions. Lord Herschel in Colquhoun and Brooks interpreted possession as meaning something possessed and which is a source of income. Lord Macnaghten construes the word in its widest and most comprehensive sense as meaning source of income. The words of the will, in this case, show that these children possess nothing, that they're not entitled to this income, the payment of which is purely voluntary. The assessment is not made on the appellant in a private capacity, but as guardian of the children. So the argument is there isn't a source, that this income doesn't have a source, because the children aren't entitled to it. And that argument is rejected if one goes to page 67, the argument of Lord Cuzzens-Hardy, Lord Justice Cuzzens-Hardy. The paragraph at the bottom, it remains to consider whether there's a possession in America in respect of which sums have been annually received in Great Britain and remitted from America. I think the trust fund is a possession in America. I cannot doubt that any income remitted from America to a grandchild after attainment of 25 would be taxable, so that's where the children have a vested interest, although the grandchild has no interest in the capital. What is the position between 21 and 25? If the trustees, in the honest exercise of their discretion, remit £1,000 a year to the grandchild, is that in any different position? I think not. When the discretion has been exercised by the trustees, and to the extent to which it's been so exercised, the grandchild is entitled to the portion of the income so remitted. The £1,000 a year so paid would be allowed to the trustees if the accounts of the trust estate were taken by the court. I fail to appreciate the argument that it be a voluntary gift, like an allowance made by a father to the son. And then the next paragraph, what's the position before 21 if during minority the trustees in the honest exercise of their discretion remit £1,000 a year to the guardian? So this is because the children are under the age of majority at 21. And then it basically says there's no difference. So in other words, there was a source, what is being said, because the children, as soon as the trustees exercise their discretion, the children are entitled to the income. And then if I go to tab 7, which is the House of Lords decision on in the same case, at page 74, could I ask you to go to page 81 in the judgment of Lord Parker. Perhaps if I could ask you to read, it only goes just to the second line on page 82, the word beneficiaries.
Do you want us to read the whole thing?
Yes, it's just Lord Parker, it's only...
Okay.
Yeah.
From the bottom of 81, yes.
Well, as I understand the appellant's argument. Yeah. So again, he's making the point that as soon as the trustees exercise their discretion, they're holding the income in trust for, in other words, the the children are entitled to it. And Lord Wrenbury at on page 83, the fourth line from the top, beginning at the time with which your lordships have to do, there could be no payment except by exercise of the discretion vested in the trustees, but so soon as their discretion is exercised in favour of the child, the resulting payment seems to me, upon the language of the will, to be a payment of income to which the child is entitled by virtue of the gift made by the testator. I cannot see any ground upon which such income is not subject to income tax. So again, he's making the same point, that it's because the children become entitled to it as a result of the trustees' exercise of their discretion that there is a source.
It's the combination of the terms of the will and the exercise of the discretion.
Exactly. Then the next case I wanted to take you to is one I've been talking about a bit, Stediford and Below. That again, it wasn't about a foreign possession, but it does refer to Drummond and Collins. It distinguishes it. It was about a discretionary decision to make an annual payment to the taxpayer, as you know. That's tab 13, page 147. And you'll see in the head note, I believe you're obviously familiar with the case because my lady referred to the headmaster. You see there, Drummond and Collins is referred to as distinguished.
We're looking in the King's Bench?
We are looking in the Court of Appeal because I wanted to take you to something which was said in the Court of Appeal, first of all, if that's all right. So you see the argument for the Crown at page 150. So, first of all, there's a reference to a case called Duncan's Executors. It was held that a voluntary pension such as this was taxable as an annuity. And then over the page, there's a reference in the middle of the page to a case called Bainan and Thorpe. Pension received as a right or with any certainty, so it becomes a piece of property, was taxable. And then there's a reference to Drummond and Collins. The argument for the taxpayer was the payments to the children were mere gifts because the trustees had a discretion. The answer was that when the discretion was exercised and the money paid, it was paid as the income of the children. So the HMRC, or the revenue there, are relying on Drummond and Collins as being relevant to the taxability of these payments in this case. That argument was rejected. If you go to the judgment of Lord Justice Romer, starting on page 162.
And this is a case 6 case, I assume?
Well,
is it?
It's actually at Schedule E,
right.
But it's rather odd because at various stages, provisions of... this is something that Lord Justice Romer explains, actually, on page 162. If I can show you what he says there at the very beginning of his judgment. It's being relied on by the Crown as being an annuity or other annual profit or gain, such as is mentioned in Clause 1B of Schedule D, which was formerly chargeable under that schedule, but is now chargeable under Schedule E. So it's being charged effectively as a pension, or an annuity or other annual profit or gain in any event. Then you see in the second paragraph he says the Crown is wrong on both points, so that it's neither a payment in respect of the office, nor is it an annuity or other annual profit or gain. And then if you go to about 10 lines from the bottom, there's a sentence beginning, I do not think, on the other hand, that it's an annuity or other annual profit or gain such as mentioned in Schedule D. The question whether it is or not seems to turn on this, whether it's to be regarded as an annual payment to which the respondent has a right, or whether it's to be regarded merely as a series of annual gifts made to him by the governing body of the college. I think it must be conceded it's to be regarded as a series of voluntary gifts made to him, unless the case can be brought within the principles that was applied in Drummond and Collins. And then, over the page, he refers to the facts of that case, the judgment of Lord Parker and of Lord Renbrew. And then the final paragraph at the bottom of 163. In the present case, Mr. Below wasn't entitled to the pension at all, nor was any part of the trust funds held upon trust for him. When one looks at the statute referred to in the Charter, the surplus income was to be held on trust for the benefit of the college, in such as the trustees may in their absolute discretion to mean most for its benefit. If there be any aesthetic trust under that, it's the college and no one else. And then 5 lines down, I think for Mr. Hill to argue that when the trustees in the exercise of their discretion applied a part of the income in making this allowance to Mr. Below, because this is the only reason they could make it, they considered that payment to be for the benefit of the college, that Mr. Below was a aesthetic trust of theirs or became entitled to the pension, or anything was held in trust for him. Certain words are merely added and so on. I don't think I need to read anymore. So what's being said is, this is different from Drummond and Collins because there is no trust in favour of Mr. Below. There is a trust, but he's not a beneficiary of it. So he doesn't get any entitlement when the trustees exercise, or the warden and council, in this case, exercise their discretion. And then at page 165 is the House of Lords judgment. And I did want to pick up the point, about if you go back to page 157, I said to Lady Justice Asplin that I would explain about the services point. And it's what Lord Hanworth, in fact, said at page 157. He says in the middle of the page, we have here a case in which the man was not entitled to receive any pension. He didn't fall within any scheme of pensions. He had no claim at all to receive any money. And it was not paid to him because he remained a headmaster. It was paid to him because of services that he'd previously rendered. But also it wasn't paid to him because such a payment was part of the contract under which he rendered the services. So there is a connection there with his services. It's just like, it's clearly a payment of an income nature, as any other pension is paid because of services which someone has rendered in the past. What prevented it from being taxable was that he wasn't entitled to it. So anyway, I was mentioning page 165 onwards, the judgment of the House of Lords. And if you see on page 166 what the Crown's argument is, a third of the way down, they say it's conceded this particular annuity is not annexed to the office of headmaster, but it still may be an annuity unconnected with the office and chargeable to tax under Schedule D, and now under Schedule E as amended by the Finance Act. The Crown is bound to admit there is here no binding contract for payment of the annuity, and the question is whether this is a regularly constituted annuity, there being in form no certiorari, but de facto an expectation that the annuity will continue to be paid. In ordinary parlance, this is a pension, and it's submitted that is sufficient to bring it into charge. And then that's rejected on the ground that he wasn't entitled to it. That's the sole reason why it's not taxable. It's, in ordinary parlance, a pension. It's something that he's expecting to get, but he's not entitled to it.
Well, when you say expecting to get, was he? Is there a finding that he was expecting to get it as part of his employment?
Sorry, I'm not suggesting there was an expectation while he was working. It's simply once they...
A post facto.
Yes, absolutely. There's a series of payments. So he's being told effectively, we decided we're going to make you these annual payments. So the expectation, I would say, arose at that point, but we're looking at, let's say, year 3 payment. At that point, he has an expectation. So Viscount Dunedin at the bottom of the page, he says it's admitted in the case that no consideration was given by him. Depends entirely on the goodwill of the governing body, who might rescind the minute.
They did have a power to apply their funds if they wished in order to provide allowances or pensions for ex-headmasters.
Yes, they had a
That
power.
was within the scope of their powers.
Yes, and they were fiduciaries in relation to that money, because they weren't trustees perhaps, but they were fiduciaries. They were exercising a fiduciary discretion in his favour. Nevertheless, that wasn't enough for it to be taxable. If one goes to the top of page 167, Viscount Dunedin says, not chargeable under the old Schedule E, not given to him in respect of his office of headmaster. Then he says, we have the later statute, which says such profits or gains arising or accruing from any office employment or pension. Then he says it must be a real profit under Schedule D, and it has been held again and again that a mere voluntary gift is not such a profit, because it's not in the true sense of the word income. It's merely a casual payment which depends upon somebody else's goodwill.
You mentioned a moment ago that it was what we would regard as a fiduciary power. Is there any discussion in the case of that element?
No, other than the Crown's reliance upon Drummond and Collins. No, there isn't. They don't. The only case the first case, I believe, which adverts to that point is the Cunard's case, which I'll take you to in a moment.
So you were still on this page. I asked that because of the reference to casual payment depending on goodwill.
Yes.
It doesn't sit terribly easily
No.
at that point.
No. Well, my submission is that what their lordships are doing there is really emphasising the point that as between the college or the officials of the college and Mr. Below, it is purely voluntary in the sense that he has no rights in the matter. But what they emphasise is that he's got no right to sue. And that, you see, halfway down 167, it was sought by the Crown to show that something else had been held by the Court of Session in the case of Duncan's executors and farmer. The point there was that an annuity had been granted upon consideration that he should give up the parish entirely. There's no question that if the annuity had not been paid, Duncan might have sued for the annuity. I think that, although not said in actual words, is absolutely deducible from the opinion I pronounced in those case. My lord, in those circumstances, I have an opinion that here the payment is purely voluntary and cannot be subject to income tax. So he's distinguishing, I would submit, between the Duncan case, where he could sue for it, and this case where he can't, and that's why I would submit he's saying this is purely voluntary. They're not considering voluntariness in the sense of having an obligation to exercise a discretion. I accept that, but equally, they're focusing on whether Mr. Below had a right to it. And Lord Warrington says on page 168, it's wholly voluntary, none of which need necessarily be continued. And then Lord Thankerton, now at the bottom of the page, he refers to Duncan's executors. He says it was a regularly constituted annuity by the society for consideration afforded by the minister. So my submission is that all of these cases are making the point that the payment either is or isn't taxable because there is or isn't an entitlement to the income. And then the next case is Cunard's Trustees, tab 18, page 193. And this is obviously an important case because it was directly relied upon by this court, by Sir Lancelot Henderson in the Blue Crest case. So,
tab 18.
yes, tab 18, page 193. If I can just summarise what the facts were. It was a trust, a will trust, giving the trustees a discretion to supplement Miss McFeeter's income out of capital. And the question was whether, when they exercised that discretion, the payments that she received out of capital were taxable income in her hands. One of the issues was not relevant, which was whether it mattered that administration of the estate was complete or not. But if I can take you to page 197. Line 4. This is Lord Green. The payments, therefore, in my opinion, were properly made, and at the moment of payment became income of the recipient, Miss McFeeters. They were in their nature entirely different from the payments in Corbett's case. Miss McFeeter's title to the income arose when the trustees exercised their discretion in her favour, and not before. At that moment, a new source of income came into existence. And then, under the express terms of the will, and not by virtue of a residuary legatee pending the completion of administration. So, the important sentence is, Miss McFeeter's title to the income arose when the trustees exercised their discretion in her favour and not before. At that moment, a new source of income came into existence. Now, why did a new source of income come into existence at that moment? The answer in my submission is the sentence before, that her title to the income arose at that moment. In other words, the source came into existence because her right to receive the money came into existence. And then between B and E, Lord Green discusses whether they were income, whether they were of an income nature. And he says they are of an income character. And then below D, counsel for the respondents argue these payments were not taxable, but on the true construction of the statutory provisions relating to Schedule D Case 3, they were not annual payments, and they were discretionary, and therefore voluntary payments, which Miss McFeeters could not claim as of right. Just stopping there, she could obviously claim them as a right once the discretion was exercised, but the point being made by the taxpayer was she couldn't claim them as a right from the beginning, and therefore they couldn't be taxable. They were voluntary. And then Lord Green discusses whether they were annual or not, and says they were. And then just above H, he says the second argument also fails, even if it be assumed that the general words are to be read as limited by the phrase a charge on any property. It's not suggested that the phrase means a charge in the strict sense. It was suggested, however, that Schedule D Case 3, Rule 1A, does not extend to mere voluntary payments. But the payments here were not voluntary in any relevant sense. They were made in the exercise of a discretion conferred by the will. It's true the trustees had an absolute discretion whether to make a payment or not, but the question whether they should do so was one which they were bound to take into their consideration. They couldn't refuse to consider whether the income of the estate was sufficient to give Miss McFeeters the required degree of comfort. The fact that after examining that matter they might come to the conclusion it was sufficient and therefore decline to make a payment out of capital does not, in my opinion, give to a payment, even when made, the character of a voluntary payment in any relevant sense. The money, when received by Miss McFeeters, was received by her through the joint operation of the will and the exercise of their discretion by the trustees. But my submission is that when Lord Green is discussing this question of voluntariness, that's a completely separate issue from the one he's already determined about source. He's already decided that a source arose at the moment that the trustees exercised their discretion. This question of voluntariness is not to do with source at all. It's a different issue.
Yes, but at the top of page 197,
Yeah.
163 of the report, actually what he's considering is income versus capital. He's not considering a right to something. I can see he uses those words, but that's not the context, is it? And then later, at the bottom of the page, he moves on to the voluntary or not issue.
Well, with respect, my submission is that what's important, because this is what is then relied upon by this court in Blue Crest, is what Lord Green says about source. Why is it that a source arose at that point and at that moment? I'll take you to Blue Crest and what Sir Lancelot Henderson said about source and relying on this case. But
you have the reference to a new source at the top.
Yes, exactly. A new source of income came into existence. And as I say, it's because her title to the income arose at that point that a new source of income came into existence.
Can I just, this may be anticipating something you're going to come back to. You're drawing, I think, a distinction in your submissions between deciding to make a payment, the trustees deciding to make the payment, and you say that gives rise to the source, that gives rise to an enforceable right, and the subsequent payment. I think you're drawing that distinction.
Sorry, I didn't quite understand the distinction you were...
I think you're drawing, and you're going to develop this, a distinction between deciding to make a payment, which in Cunard's trustees, you point to a passage which says that creates a source, and the subsequent payment. And you're saying it's the decision is all important as giving rise to a right. The question I had is, Lord Green didn't have to consider a situation where, for example, the trustees make a decision, but then some intervening event happens, the stock market crashes or something like that. Between making that decision and then making the payment, would that have made any... And they might then reconsider their decision. Does that make a difference?
Well, I suppose the question is whether the trustees have power to, as it were, change their minds and say we're not going to pay.
The reason I ask the question is that you interpreting this as meaning, right, she's got an enforceable right at that point.
Yep.
Whereas I'm saying it's perhaps not quite as
not as black and white as that. Well, let me put it this way then. Perhaps one could say that Lord Green, if he were asked that question, would say Miss McPheeters had a sufficient title to the income if she could claim it subject to certain contingencies, which in the event don't occur.
Thank you.
So clearly he wasn't addressing that question, but when he says her title arose, he's clearly talking about her having a right of some kind. And my submission is that in this case, the individual appellants did not have a right, an absolute one or otherwise. The next case is Sprite, which is at tab 30, page 563. Sorry, we're jumping around in the bundles of authorities here.
Can you give me that reference again? It's tab 30. Did you say?
Tab 30, page 563. don't need to ask you to read the head note. The facts are very, very simple. It was a tax avoidance scheme involving 3 group companies, companies A, B, and C. Company A made a loan to Company B on terms that Company B, the agreement was that Company B would repay the money and would pay interest in the form of issuing shares in itself, but it would issue those shares not to Company A, the lender, but to Company C, which was a member of the group, but which was not a party to the agreement and had no rights under the agreement. For example, the Contracts Rights of Third Parties Act was specifically excluded. So Company C had no rights in the matter at all. But it did receive the shares were duly issued to it. And one of the issues in the case was whether Company C was taxable in respect of the shares it received. The argument to the contrary was that it had no rights and that therefore it had no source of income. It didn't possess a source. That was rejected by the FTT and the Upper Tribunal. In that case, as in this one, it was common ground. It was accepted that the shares that Company C received were of an income nature. So the only issue was source. Now, this issue is discussed by the Upper Tribunal at page 576 onwards. If I can take you to paragraph 54 at the very bottom of page 576, which records my argument, but unfortunately it records it wrongly. It says, Mr. Prosser's primary argument was it's not enough that a person receives something for tax to be chargeable. The argument as we see it breaks down into 4 elements. 1, the receipt must have the character of income. 2, it must be the recipient's income. 3, it must have a source. 4, there must be a sufficient link between the source and the recipient. And then if one goes, well, if I can just stop there and say, what the Upper Tribunal then go on and say is there's no argument about it there being a source. The issue was whether there was a sufficient link between the source and the recipient. But that wasn't my argument. My argument was simply that there wasn't a source. And that this question of a link between the source and the recipient is a non-issue. The question is simply, this concept of possession and so on, as I've already mentioned, is the same as the source existing. It's one and the same issue. So the tribunal then goes on and discusses those various...
Sorry, just to be clear, you were effectively putting the point you're putting to us.
Yes, I was. Yes, I was simply saying, I referred, and the tribunal records me referring to Bray and Best and Pumahaven and so on, and saying that the source must exist and must be possessed. But they nevertheless regard that as directed at the question of whether there's a link with the source, rather than whether there is simply a source at all. So if we go to page paragraphs 58 to 9, see there's a discussion halfway down about Stedevon and Below. And then at paragraph 61 to 4, on page 578, there's a discussion of Drummond and Collins. If I can just refer you to what's said at paragraph 64, they say, Lord Parker of Waddington, too, spoke in the language of interests and entitlements, rather than enforceable legal rights. The word entitlement can be limited to the right to receive, rather than the right to enforce payment. So just stopping there, the Crown's argument in Sprite Beam was that Company C was entitled to the shares, albeit it had no enforceable right.
Entitled?
Yes, it was entitled. That was the argument. It was entitled to the shares, albeit that it had no enforceable right. It couldn't sue to enforce that entitlement, but it was entitled to them. Now, I didn't understand that argument, and I still don't. In my submission, Company C had no rights in the matter at all. Entitlement means just the same as rights. There's no difference between them. And then still in 64, it said, in Lord Parker's it didn't matter that the mother wasn't a beneficiary and couldn't control the property, although control is often the badge of enforceability of a legal right. Well, with respect, that's a non-point as well. The mother was simply the person being assessed as guardian of the children. In Drummond and Collins, her rights in the matter were completely irrelevant. She was simply the representative of the children. It was the children's position that was focused on by the House of Lords. I mean, one issue was whether she could be assessed under Section 41 of the Income Tax Act 1842, but that was a separate issue from the position of the children. So the reference there to the mother is a red herring in my submission. And then if we go to page 579, paragraph 66 to 67, there's a reference to Cunard's trustees. And then if I can pick it up at paragraph 68, the conclusion we draw from the authorities to which we've referred, that it's immaterial that the recipient cannot enforce payment. What matters is whether there's an obligation on the payer to pay. Thus, in Stediford, there was no obligation on the governors to make any payment. By contrast, in the trustee cases, the beneficiaries individually could not enforce the payment of any particular sum to themselves, but the trustees were under an enforceable obligation to exercise their discretion and make a payment to one or more of the beneficiaries as circumstances required. Well, the beneficiaries could sue. They couldn't give a good receipt for the money, but they could sue in the name of their parents. So that was just a bad point. Just because the children were under the age of majority doesn't mean that they, first of all, they had rights. Secondly, they could enforce those rights. So what the tribunal is saying...
They couldn't enforce the payment of any particular sum to themselves, could they?
Well, once the trustees had exercised their discretion...
Oh, that's different, yeah.
Yes, but that is the point, that once the trustees had exercised their discretion, the children had a right to the title to the money, which they could enforce. And what the Upper Tribunal is saying here is that they couldn't enforce it. What mattered was that the trustees had an obligation.
Sorry, I think I'm being slow. Is that what the Upper Tribunal is saying?
No, it is.
Which words are you relying on to support that? You're looking at the...
Well, opposite G, by contrast in the trustee cases...
Well,
perhaps, if I can read on, in Drummond, for example, the payments were not voluntary payments in any relevant sense, because the payments were made on the basis of the trustee's duties arising under the testamentary trust. Perhaps I'm wrong then, in that they're referring to the position before the discretion is exercised.
Yes.
That's the point instead of they're making, they make the same point.
Right. But my submission is that what's being said in Drummond and Collins is, let's focus on the time at which the trustees exercise their discretion. At that point, they have a right. And again, in Cunard, Lord Green says at that point, the source of income comes into existence.
do you say that's both in Drummond and Collins and Cunard?
Yes, the position before, I accept, okay, there is no right individually to demand a payment. But that's irrelevant, because what we're looking at is whether there's a source at a later point. I mean, when Lord Green says a new source of income comes into existence, clearly he's not postulating that there was a source beforehand. The mere fact that the trustees had an obligation to consider whether or not to make a payment, he clearly didn't consider that was a source of income.
Well, would you accept that those cases do regard it as relevant that there's the context of the will, trust, or whatever it is, together with the decision to make the payment? It appears to be that combination.
Well, that combination is vital because it's because of the terms of the trust, coupled with the exercise of the discretion, that gives rise to the right to the title to the money. It's that combination, because obviously the trustee's discretion by itself doesn't give you any right. It's the fact that that completes the testator's gift.
Well, if you're a beneficiary, it gives you a right to have the trust properly administered and those powers to be properly exercised and considered. But
Yes.
that's all, not for a specific sum.
No, but that's absolutely right. But as soon as the trustees exercise their discretion, the combination of the terms of the trust and that exercise of discretion give the beneficiary the right, a new source of income, to the money.
And that's why you would say it's different in the Below case, because Mr. Below individually or as an ex-headmaster wasn't specifically a beneficiary of the trust.
He wasn't a beneficiary of the trust, and therefore, when the trustees exercised, or the warden and council exercised their discretion, as against Mr. Below, the payments to him were voluntary, because he, unlike the beneficiary, Miss McFeeters, could not at that point say, "This is my money." And so there was no source as far as he was concerned. It was voluntary. There was a source for Miss McFeeters. The point I'm making here in relation to Spike Beam is that the Upper Tribunal are saying what matters is there's an obligation. That's not the language that's used in any of the cases. The language used in the cases is one of entitlement, and that makes complete sense when one sees the concept of a source as being something which the taxpayer has. He doesn't have an obligation. It's that he's got the correlative of that, which is the right.
But to take my lady's point, could you not follow that through? My Lady Justice Falk talked about, well, you could say that the entitlement follows from the fact that a discretionary decision has been made, that it's context-driven. Because in both of these cases, you've got the exercise of a discretion, and at a very basic level of analysis, you could say it's a bit odd because in one case you end up with a source of income and in the other you don't. So what's the difference between them? And the difference is context. That's
Absolutely.
everything. In one, there's a trustee, there's a will that sets out a whole background and understanding, and in the other, there isn't. There's just a headmaster who's retired.
No. With respect, instead of an abelo, there's a charter as well, which sets out the powers which the warden and council can exercise.
Yes, the warden and the council, but nothing that says, as a headmaster, you can have some sort of expectation that we will pay you a decent pension.
It's true that there's no... I haven't taken you to the terms of the charter, but they expressly give a power to the warden and council to decide to pay a pension to a former headmaster. There is that express power.
Well,
It's set out in the charter in the same way, except that because he's not a beneficiary of that trust, it doesn't give him any rights.
Yes, I think
That's the point.
that was the point, and that you showed us that when we were looking at Below, that there was, within their range of powers, there was a power to pay such a person a pension of some kind.
Yes.
And of course, therefore, they weren't stepping outside the proper exercise of their powers, but he was not a beneficiary, so the circumstances were different.
Exactly. So the context is provisions which determine, which give someone a discretion to exercise. The difference between them in my submission is that in the headmaster did not, as a result of that discretion, have a right to receive the money. It's true, he also didn't have a right to be considered. But going back to Cunard's trustees, the source arose when the discretion was exercised, not when the question arose whether it should be exercised.
but only in the context of beneficiaries who did have a right to be considered. I mean, it's not suggested that in Mr. Stedford's case that any source arose when someone actually did decide to make the payment. As my lady says, the context is critical.
The context is critical, and my submission is the context in this case is, yes, we've got someone having a discretion, but it's not, well, I make 2 points actually. First of all, it's an unfettered discretion, and secondly, it's one which, when exercised, does not give a right to receive the special capital. So those are my sort of fact-sensitive points, as it were, or context points in this case.
Is it too simplistic to say? You say you're much more like the Stepford sort of case. You're much more like the headmaster than you are like the beneficiary of a will.
Well, my submission is, crucially, it's not just sort of a comparison of the facts, that we are unlike Cunard's trustees because no title to income arises at the moment of the exercise of the discretion. That we don't have the right to receive the income. And I would also submit that nor do we have even a right to be considered. So there are no rights in the matter at all. And in that sense, yes, it is much more like Mr. Below, in fact, who had no rights in the matter, even though there was a sort of a fiduciary element to it, because those fiduciary obligations were owed to the college and not to him. So yes, if one's comparing the facts, it's much more like Mr. Stediford and Below, but the key point about the facts is whether there's any rights involved. Could I then take you to page 579, paragraph 66 to, I've taken you, I think, to paragraph 68. So if you go to 69, we did not understand Mr. Prosser to argue that the obligation imposed on the borrower to issue the shares did not represent a source, or put another way, that the source of the income was not the true value of the money lent. Thus, there's no issue between the parties about issue 3. Mr. Prosser's point, rather, was that there was no or no sufficient link between that source and the share recipient. Well, that's, I mean, it may not matter, but
that's what you say is
that's
wrong.
not what I said at all. No. And then you see at 70, Mr. Prosser began with a submission that a source is limited to a kind of property or a kind of activity, and then so on. And then there's a reference to Brown. And then 74, Puma Haven. So one wonders why, given that I'm quoting Puma Haven and saying the source has to exist and be possessed, in any event, they misinterpreted. Not my fault, it must have been my fault for not making my submissions clear. And then at 76, Mr. Prosser used this language as a justification for the requirement that there had to be an enforceable right in respect of the income-bearing property, such that tax is charged only so long as a taxpayer possesses a source of the income. Then they're quoting from a textbook there by Natalie Lee.
So is it fair to say they are considering your actual argument
Well,
at this point?
maybe at this point they are, yes. And then Bray and Best is referred to at 77. And another case, 78, a case called Property Company, where that was Dr. Avery Jones and Sir Stephen Oliver. Such income is not taxable because the individual did not possess the source in the year. And then at 80, however, this is no more than saying that if a taxpayer's connection with the source ceases, he can no longer be taxed on receipts from that source. I mean, just stopping there, I think it's not obviously earth-shattering, but I think it's important to get this right, that as we've seen from Bray and Best, there's no difference between the source ceasing to exist and the taxpayer no longer possessing it. The source isn't an independent thing which goes on, as it were, even if the taxpayer no longer possesses it. They're one and the same thing. So to say it's no more than saying that if the taxpayer's connection with the source ceases, he can't be taxed, that's just wrong. The source ceases, full stop. It's not that he doesn't have sufficient connection with it any longer. It doesn't exist. Similarly, we regard Mr. Prosser's argument from the situation where the taxpayer has never possessed the source as merely a logical extension of the rule that a taxpayer cannot be taxed on receipts when he no longer possesses the source. When rephrased to remove the language of possession, well, why are we removing that language? Because it casts light on it in my submission. No extension is appropriate or necessary. The rule is merely that the taxpayer cannot be taxed on receipts if he does not have the necessary connection with the source. Once the connection has been identified, it's necessary to look behind the receipts in the tax year in question to see if the source of income continues or has ceased. Again, I would submit that's wrong. But that necessity says nothing about the nature of the connection. Mr. Gosh's argument was it was the share recipient's status as a counterparty to an absolute obligation to pay interest. That's relevant. Then he compared Drummond and Collins and Stediford and Below. And then 82. Here, the source of the share recipient's income was the loan agreement in which it was the named beneficiary. It was entitled to receive the shares by reason of its being so named, even if it didn't have the capacity to enforce that entitlement itself. So Mr. Gosh was saying that Company C was entitled, even if it couldn't enforce it. It was entitled in the same way as the beneficiaries in Drummond and Collins were entitled. Well, that's just plain wrong as a matter of law. That it wasn't entitled at all. But then they say at 83 they prefer his arguments. Then at 84, we think Mr. Gosh is correct to say the required connection between taxpayer and source needn't be limited to legal rights, but can include the situation where the payment is made pursuant to any legal duty owed by the payer. That proposition is consistent with what was said by Lord Green in the passage we've set out, in which the focus was on the payer's obligation to the recipient, not on the recipient's ability to enforce it.
I'm sorry, I've lost where you're reading.
This is at 84.
Thank you.
So they say it's whether the payment is pursuant to a legal duty, and they say that's consistent with what Lord Green said, in which they say the focus was on the payer's obligation to the recipient, not on the recipient's ability to enforce it. And that misses out, in my submission, what Lord Green was fundamentally focusing on, which was that the title, the beneficiary's title to the income, arose at that point. That was why there was a source. So to ignore that reference and say, well, there was just an obligation is wrong in my submission. So that's why I submit that the Upper Tribunal, I mean, it was very convenient in a sense for the Upper Tribunal to say you don't have to have a right, it's sufficient that someone has an obligation, even if not an obligation owed to you. That is the source. But the concept of an obligation being a source is a very odd one if one understands source as being something which you possess or acquire or have. Could I then go to Blue Crest? This is tab 37 in the bundle of authorities. I think I've taken you to the Court of Appeal, but I wanted to go first of all to the Upper Tribunal's decision. So it's tab 37, page 1076. Now, I accept that the facts in Blue Crest are similar in many respects to the facts of the present case. They both involved a partnership of individuals who were party to deferred remuneration arrangements, where profits were allocated to a corporate partner, which subsequently made contributions of what were called special capital back into the partnership, of which then the corporate member decided in its discretion to reallocate to the individuals. Those are all the same. But the facts were different, importantly, in certain respects. So that in Blue Crest, the provisional, what are called indicative awards, were made to individual partners, subject to certain specified criteria. And if those criteria were not met, the awards were, as it was put, would be forfeited. However, the individuals understood and were given reassurances that they wouldn't lose their awards in any other case. So if I can refer to page 1106. So this is in paragraph 71 of the Upper Tribunal's judgment decision. At subparagraph 7, these were factors relied upon by HMRC. Mr. Dodd confirmed in his evidence that although individual partners accepted they could lose their awards if they didn't comply with the terms of forfeiture, their understanding was that an award would not be taken away in any other case. This was made clear to the partners, and they were given reassurances to that effect. And likewise, on page 1107, at paragraph 72, 2 to 5, if I could ask you to read those 4 subparagraphs in 72, 2, 3, 4, and 5. And then at 73, although we are satisfied that individual partners had an expectation of receiving their final awards, and that the special partner generally had a contractual obligation to give effect to those expectations unless the forfeiture conditions were met, we're not satisfied that we should treat the rights as rights to share in the profits. That's the section 850 point. And then if we can go to paragraph 75 on page 1108, the last sentence there in paragraph 75, we are satisfied, therefore, that until the corporate partner exercises discretion to make a final KIP award to a partner, the partner did not have a right or entitlement to it. Now, I would suggest that when they say until the discretion was exercised, the partner didn't have a right to it, they're saying that when the discretion was exercised, they did have a right to it. That's the force of that point, that until something happened, you didn't. It was dark until 5 o'clock. It doesn't mean it carried on being dark until 9 o'clock. That's when things changed. And then, so what effectively the Upper Tribunal is saying is that the corporate partner had a discretion which it had to exercise in good faith and so on. But even when it decided that the various criteria, the objective criteria, were met, and decided to make an award, at that point, the partner became entitled to it.
This is all, this part of the decision is all in the context of the 850.
It is, absolutely. And then if one goes to paragraph 124, paragraph 124, here the Upper Tribunal is considering Sprite beam. And at the end of 124, they say the source need not be limited to legal rights, provided there's a legal obligation to make the payment. Then they say at 125, we found that the corporate partner had a contractual obligation to give effect to the expectation of the appellants that they would receive a final award of special capital unless they failed to meet the eligibility criteria. The decision of the corporate partner to reallocate or transfer special capital was therefore capable of being the source of the awards made, as the FGT found. Then they say, moreover, the fact that the appellants did not have a contractual right to payment, but only to ensure that the corporate partner exercised its discretion fairly, and so on, did not in our judgment prevent the FGT finding there was a sufficient connection between each award and the corporate partner's decision. So there the Upper Tribunal is making a distinction between two questions, whether there's a source and whether there's a sufficient connection, which I've submitted is not the right question to ask. But in any event, my submission is it's clear from what the Upper Tribunal said in Blue Crest that once the decision was taken that the various criteria had been satisfied, at that point there was a right to the payment. If I can then turn to this court's decision in Blue Crest at tab 38 and what Sir Lancelot Henderson said about that question. one goes to page 1165. I should take you to paragraph 63 on page 1165, where Sir Lancelot says, I would observe that the Upper Tribunal's references to there being a contractual obligation to give effect to expectations and to a provisional award always being made final unless the forfeiture conditions were met, and to the corporate partner being in practice bound to exercise its discretion in those circumstances, do not, in my view, fully reflect the FTT's more nuanced findings. In particular, one of the purposes of the PIP was to address the problem of the lack of recourse against partners who had made profits and then made losses. My understanding is that a provisional award could not only be forfeited if the eligibility conditions were also met, but it could also be reduced where losses had been incurred. Well, that doesn't cut away from the point that I'm making, that taking on board all of the various criteria, not just the eligibility conditions, but also whether losses have been made, once the corporate partner has assessed all those and decided, yes, you still qualify, at that point, a right arose. So what I'm saying is, Sir Lancelot Henderson isn't suggesting that that wasn't the case. He was just saying there were more conditions that needed to be met. And the reason he's mentioning that is doing so in the context of Section 850, because he's saying there's a slightly wider series of conditions that needed to be met. So it wasn't quite as certain as all that in relation to the Section 850 issue. And then on page 1166, the next page, paragraph this is part of paragraph 64 of Sir Lancelot Henderson's judgment, and you see it, paragraph 75. He's setting out.
Sorry, this is setting out
quoting
part
from
of
the
UT.
UT.
It's part of the UT, exactly. And the reason I'm mentioning it is that 75, the last sentence there, is we're satisfied that until the corporate partner exercised its discretion, the partner did not make an award to a partner, the partner did not have a right to it. So Sir Lancelot's got that point on board, is what I'm saying. He hasn't overlooked that paragraph. And then if I can go to page 1180. So you see at the top of the page, 1180, there's a reference there to the second ground, that there was no source.
So we're now in the miscellaneous income.
Exactly. And then if we go to page 1181, the very bottom there, paragraph 119, is where he considers this question of source. Now, I just wanted to make one point. It's clear that Sir Lancelot was considering whether there was a source is a question of law. And I don't know whether that's common ground or not. But, yeah, Mr. Chaco nods. So it's not as if this is an Edwards and Bairstow type question. It is a question of law whether there is indeed a source in this case. So if I go over to paragraph 120, first of all, Sir Lancelot refers to the Upper Tribunal's discussion of Sprite, Beam and Cunard. And then he discusses Cunard himself at 121. And then you see at the bottom of page 1182, he sets out what Lord Green said. Ms. McFeeter's title to the income arose when the trustees exercised their discretion in her favour and not before. At that moment, a new source of income came into existence, his emphasis. And then at 122, further arguments about them being voluntary and so on. And then 123, Cunard was relevantly a case about case 3 of Schedule D, but there's no reason to suppose that what Lord Green said is not equally capable of application for the purposes of Case 6 or Section 687. I therefore see no difficulty in holding that a source for the final PIP awards may be found in the exercise by the corporate partner of its discretion whether or not to follow the recommendations of the board and make the awards, especially as it's common ground that the discretion wasn't unfettered and had to be exercised in accordance with the principles of the Braganza case. I don't think 124 is relevant. Now, my submission is that when he says what Lord Green said, he's not ignoring what Lord Green said about Miss McFeeter's title to the income arose when the trustees exercised their discretion. That was part of Lord Green's reasoning, and Sir Lancelot fully appreciated that as part of why it is that a new source of income arose, came into existence. And then he says, especially, 123, especially as it's common ground the discretion was not unfettered. My submission is the reason why he makes that point is because really it's all, in those circumstances, on all fours with Cunard itself. We've got a discretion which is unfettered, as in Cunard, and when it's exercised, as we've seen from what the Upper Tribunal decided, at that moment, a right arose. It wasn't a title to the income in the trust sense, it was a contractual right, but there's no difference there, I would submit. And that's why a new source of income arose at that time as well. What I would submit Sir Lancelot is not saying is that a source can be found in exercising a discretion which must be exercised in good faith, even if it doesn't confer any rights. He's not saying that, I would submit, because that would be to ignore a crucial part of Lord Green's reasoning as to why a source of income arose. So those are my submissions on the requirement for there to be a right. And then I just want to apply them to this case. Why it is that in this case there was no such right. And secondly, if I'm wrong about the requirement for there to be a right, and alternatively, it's sufficient that there's a discretion, but a fettered discretion, why there was no fettered discretion in this case. And I'm hoping I can deal with that very briefly. So, first of all, in terms of whether there was a right or not, I mean, we've consistently argued this both in the FTT and the Upper Tribunal. And there's been no finding by the FTT, or indeed by the Upper Tribunal, that when the discretion was exercised, there was a right. If I can refer you to what the Upper Tribunal said, this is in the core bundle at tab 11.
To what extent is this a question of law, as in a question of interpretation of the partnership deed?
I would submit that it's not exclusively a question of interpretation of the partnership deed, but it is first and foremost a question of interpretation. In Blue Crest, the Crown, for example, in relation to their Section 850 point, when they were saying what sort of contractual rights there were, looked outside of the terms of the LLP deed itself, and I would submit that's correct. It is not exclusively to do with the LLP deed.
Okay. I think I've got your submission. You say first and foremost is a question of interpretation.
Yeah.
Thank you. So, Upper Tribunal.
Yeah.
So divider 11, which page?
If I could take you to page 156.
Thank you.
Paragraph 28, if I can pick it up there. The FTT decided a source existed because, even if the members had no right to require reallocation, so just stopping there, even if the members had no right, that was what the FTT said. So they're certainly not suggesting they did have a right. What they were saying was, well, even if they didn't have a right, Any reallocation that took place did so in accordance with the provisions of the LLP deed, and by virtue of those rights, there was therefore a relevant relationship between the reallocation and the individual member's rights under the LLP deed, such that there's a source for the purposes of section 687. So that they're effectively saying, well, look, the LLP deed conferred various rights, and what was done pursuant to those rights, and that's good enough for there to be a source. My submission is that's not good enough, that there has to be a right to receive the special capital. And then it says the FTT also considered the activities of the individual members, finding that the payments were made to reward them for their performance and to incentivise particular behaviour. There was a connection between those activities and the subsequent reallocation of special capital. So that point about there being a connection, again, is going back to Sprite Beam and saying, is there a sufficient link with the source, rather than, in my submission, the correct question, which is there a source at all? And then 29, the FTT thus held a source existed for two reasons. The appellants challenged both those findings. We deal with them in turn, but in essence, the appellant's core argument is that for both, there needs to be a legal obligation on the payer to pay. Well, that was, to be frank, expressed in Sprite Beam terms, but I now rephrase it, obviously. There must be a legal right to be paid. As that was lacking in this case, it's argued the FTT was wrong to find that the requirement there be a special link between the source and payment was satisfied. Again, with respect to the Upper Tribunal, I wasn't suggesting in that case either below that it's a question of there being a sufficient link. But nevertheless, I was obviously to some extent stuck with what was said by the Upper Tribunal in Sprite Beam. And then 32, HMRC argue the concept of a legal obligation to make payment includes the effectively broader set of situations where payment is made pursuant to a legal obligation. The key principle is not about whether someone can sue to enforce payment, but that the payer acts according to legal duties and not freely. This is so as to distinguish payments by trustees on the one hand from gifts on the other. In stark contrast, the appellants argue Blue Crest has authority for the proposition that a legal obligation to act rationally in considering whether to make a payment is not sufficient. Both parties therefore rely on Blue Crest. So no one's suggesting that there, in terms of what the FTT found or the Upper Tribunal found, that there was a legal right to payment. What's being said is, well, you don't need one. So it doesn't matter that there wasn't one. Can I then take you to the LLP deed? This is at in the supplemental bundle, tab 1. Page 4 is the LLP deed. Now, this is on page 7. It says it's dated the 28th of October 2010. The FTT noted in its decision at paragraph 25 that this agreement was negotiated between GSA's lawyers and Alexander Gerko's lawyers between August and October 2017, and then it was signed in October 2017.
Sorry, which paragraph the FTT?
Paragraph 25.
Yeah.
So this is a professionally drafted agreement agreed as a result of negotiations between teams of lawyers. Now, if you go to page 19, paragraph 11.9 is headed Special Capital. Could I ask you to read that? But it's rather oddly structured, and so could I ask you to read A, and then C, and then go back to B? Don't worry about D, but I think it would make more sense if you were to read it in that order. So A is first of all to do with contributions of special capital, then C is to do with reallocations of special capital, and B is to do with restrictions upon reallocations of special capital. So A, C and B, please, and we don't need to bother with D. So, if I can make 4 very quick points. First of all, looking at 11.9a, the top of page 20, subject as hereinafter provided, that part of that subclause, the money standing to the credit of a special capital account shall be held exclusively for the benefit of the relevant member, and only the relevant member shall be entitled to such monies. No other member shall have any interest in such monies. In my submission, the first point I make is that it's clear that GSAM's special capital, when GSAM contributes special capital back into the partnership, that's held exclusively for its benefit. No other member has an interest in it, so that unless it's specifically provided for, there's no specific provision anywhere. It follows that GSAM is not a fiduciary in any sense in relation to the special capital that is credited to it, that belongs to it.
Just to note there, I know you will say this is irrelevant. There is reference in the fact findings to the purpose trust under which that entity is owned.
Yes.
You say it goes no further than that.
Well, my submission is that is a relevant point, I would submit, because I'm going to be saying that GSAM, the retention member, not only had no obligation when it made a decision to reallocate, had no obligation then to follow through with that decision. It could reverse its decision, but also it had no Braganza type obligation in relation to that decision. Now, one may say, well, that's a bit odd. Are you suggesting that GSAM, it's been given this enormous sums of money, could then walk away with it? Well, that's where the purpose trust comes in, because its shares are held on the trusts of a purpose trust, Cayman Island Purpose Trust, which provide that the purposes of that trust are to benefit the businesses, not only of HFFX, but also of this other partnership of which is sort of wider than HFFX, the GSA Capital Partners LLP business, so that is the constraint, where the constraint would be exercised, that the trustees of that trust would make sure that they would never allow GSAM to, as it were, run off with the money. So that one doesn't need to interpret this LLP deed to prevent that happening, because one's got the constraint already at the level of the trusts of the shares. But I would submit that provision, that purpose trust, that restriction is not a reason to read in a similar restriction here. It's on the contrary, it's a reason to take the words that are used at face value. And I'll come on and say what words are being used in a moment. But the first point was, in any event, that GSAM is not a fiduciary in any sense in relation to the special capital. No one has any interest in it apart from GSAM itself. That's what 11.9a says. Mr. Yates points out that paragraph 11 of the FTT decision, the FTT recorded that this is a purpose trust with no beneficiaries. So it is a purpose trust as such, rather than one for particular individuals or other beneficiaries.
Thank you.
That's the nature of a star trust.
It is, exactly. So then if one looks at 11.9b, at any time prior to reallocation, various things could happen. So it's not at any time prior to a decision to reallocate, it's any time prior to reallocation that there could be events occur. For example, B1 talks about a liability incurred as a result of acts done by members of the HFFX. So if an act is done between a decision and the time when GSAM would otherwise actually follow through with that decision and reallocate, then in those circumstances, the what's called the corporate member, that's GSA CS could step in and say, no, don't reallocate. So that's an indication in my submission that the decision to reallocate on the part of GSAM is not one which is giving rise to legal rights, because various things could happen to prevent that decision being followed through. I accept what Lady Justice Falk said about events occurring subsequently, but this is an indication. There are other indications I rely upon to suggest that the decision itself has no legal consequences. And then if one goes to 11.9c, the first subparagraph, we're told in the middle of that it's in the second subparagraph there. We're told that recommendations are to be made in the form set out in Schedule 6.
Yes, I found you said the order was odd.
Yeah.
Isn't this second paragraph getting at what happens at a much earlier stage?
Well, yes, that's true.
As in, we've started in A with the capital coming back in.
Yeah.
But that's at the ends of years 1, 2 and 3.
Yeah.
Whereas isn't this getting at the prior stage?
It is. It's true.
In other words, when the amounts are provisionally determined.
Yes, absolutely. But the recommendations go further than that. If I can just show you what's in Schedule 6. This is on page 56. So it's true that the initial recommendation comes earlier on, but it's actually a series of ongoing recommendations on page 56. So, and that includes B to D on page 56. What's to happen on the first, second, and third anniversaries?
Yes.
And then at E, at the end of 1 month following the contribution of special capital, in accordance with B, C, and D, and subject always to the conditions set out below, the company should reallocate such special capital to the following members. That's the recommendation. But then what I'm relying upon is subject always to the conditions set out below. And if one goes over to page 57, at H, no special capital may be reallocated to an individual identified at E above unless they remain a member on the date of the proposed reallocation. And I, where an individual has ceased to be a member, any special capital recommended to be reallocated shall be reallocated instead to the corporate member. Yeah. So there again, and then I can take you back to the clauses of the deed which set out the circumstances in which someone could cease to be a member. And there are circumstances. There's an example of this in relation to one of the individuals.
So, just to clarify the terminology, as I understand it, restricted member covers a good leaver. Is that broadly right?
Yeah. Yes.
So if you're a good leaver, you might be allowed to stay on as a so-called restricted member to collect on the
more, exactly. But if someone acts prejudicially, seriously prejudicially to the interests of the business of HFFX, they can be terminated forthwith and cease to be a member without notice.
Yes.
And there is an example of that in relation to one of the members, Mr. Badzian, so that the recommendation was made in relation to him. GSAM made a decision in his favour to allocate special capital to him, but before it gave effect to that decision, he left. Or in fact, he went and joined rivals, and that was discovered, and he was dismissed. And in those circumstances, he didn't get any award.
And we're told that the monies were used to fund litigation against
Yes,
him.
exactly. So that, again, my submission is that this is an indication that the decision to allocate has not got legal consequences. It's
I'm sorry. I thought the decision to reallocate that you were focusing on was pretty close to the end of the process. The special capital's gone back in,
Yeah.
and then the GSAM can decide in its discretion to reallocate.
Yeah.
The Mr. Badzian example, as it happens, is at an early, as I understand it, is a much earlier stage of the process.
No. That the example with him is even after a decision had been taken by GSAM to reallocate in his favour, it was discovered that he'd gone off and joined rivals, and GSAM reversed its decision.
Oh, I see. But that's a particular, yes. But the general point you're making about the second paragraph of C is talking generally about the earlier stages of the process, is it not?
Well, the point.
That's worth.
No. What I was trying to say about the second paragraph of C was simply that the things were being done in accordance with recommendations, that those recommendations were in accordance with the form set out in Schedule 6, which made it clear to the members, to GSAM, that you, even if you decide to make a reallocation, you don't make it in certain circumstances. In other words, what's important is what the position is, not at the time you make the decision, but in the sense that if something happens after you've made the decision, you mustn't go ahead with that decision. And the example actually happened with Mr. Badzian is that GSAM had made the decision but then reversed it.
Yeah, and again, to be clear, Schedule 6 is what goes to GSAM.
It is.
Schedule 7 is what goes to the individuals. It's referred to later in the same paragraph.
Yes. That, what it's worth on page 58, says that the company may then, in its discretion, reallocate that capital. This is at D. It's not may, in its discretion, decide to reallocate. It's about the process of allocation rather than the focus is on the reallocation, not on the decision to reallocate. And then the other point I wanted to make about that, if we go back to the first subparagraph of 11.9c, we see there it says that any member may, in his sole and absolute discretion, decide to reallocate. And then it says, so that such other member will, following such reallocation, become beneficially entitled to the relevant part of such special capital. So again, the focus is on the consequences of the reallocation, what happens following the reallocation, not on the decision. And then the only reference to the relevance of the decision is it says, and shall give notice of any such decision to the managing member. So there isn't a requirement to give a notice to the, as it were, the beneficial member, the one who's going to receive the reallocation. They're not told. This doesn't require them to be told about it at all. Now that, again, in my submission, is significant because if the making of the decision had legal consequences, one might expect notice of that decision to be given to the person to tell them they've got some legal rights. But there isn't any such requirement. It's only the managing member, Mr. Gerko, who has to be told about it, not the, as I say, the expected recipient.
I haven't quite caught up with where is the obligation? Is there an obligation under clause 11 to serve a Schedule 7 notice?
Well, no.
Well, Schedule 7 is referred to in the second paragraph of C. As I understand it, the way I read the letter in Schedule 7 is it's sent at a much earlier stage of the process.
Yes.
Effectively, when the profits go to the corporate member in the first place, or around that time.
That's right.
Whereas you're focusing on the position 1, 2, or 3 years later.
I'm focusing on, so that what happens is you have a notice of a recommendation given by Mr. Gerko to the members saying, look, this is what is expected to happen in the future. That on various anniversaries, the first, second, and third anniversary, GSAM will contribute the monies that it's received back in as special capital, and then will allocate to you in accordance with my recommendations. But so that's Schedule 7, that's what the members are told, but they are told, as I say, and this is in Schedule 7.
Little D tells them what's going to happen, doesn't it?
D, yeah, the company may then at its discretion reallocate. So my submission is the focus is on the reallocation rather than on the decision again. And again, as I say, that 11.9c, the first paragraph, is saying that if someone decides to reallocate, they have to tell Mr. Gerko they've decided, they have to give him notice of that decision. They don't have to give notice to the person in whose favour they've decided to reallocate. So that everything is pointing in my submission to there being no legal consequences of a decision to reallocate. The consequences arise at the stage of the reallocation itself, and until then, it's perfectly possible for GSAM to change its mind.
For any reason, or only for B reasons?
Well,
9B reasons. In other words, if there was a reason, if there was just we've changed our mind, not because you've done anything that is contrary to the interests of the company, but just a change of mind, would a member, an individual, have a right to sue at that point?
My submission is that there are no rights at all, and I wanted to make that good, perhaps after the short adjournment, by reference to, this will only take me 10 minutes, by reference to the proposition that there isn't even an obligation, a Braganza obligation on GSAM. I could do it now if you wanted me to.
I think 2 o'clock is the right time. I'm very concerned about the amount of time. I appreciate these are very difficult and very important issues, but we did agree, I think, at the beginning that the whole of the issues which were now before us could be dealt with today, and it seems to me that we're running close to the wire in getting just the miscellaneous income issue dealt with today. And so I think that although, of course, I don't wish to place you under any constraint or to reallocate anything in any way, that really we need to have moved on very shortly after 2 p.m.
We will do that.
Thank you very much.
All rise in favor.